Welcome to the Culture of Healthcare, Ethics, and Professionalism. This is Lecture B. The component, The Culture of Healthcare, addresses job expectations in healthcare settings. It discusses how care is organized within a practice setting, privacy laws, and professional and ethical issues encountered in the workplace. The objectives for ethics and professionalism are to provide an orientation to ideas about medical ethics and professionalism, explore the relationships among ethical ideals, professionalism, and legal duties, apply the general principles of ethics and professionalism to specific topics, examine ethical issues in health informatics. This lecture discusses ethical and legal standards and how they interact. People in the medical profession are required to meet both ethical standards and legal standards. Sometimes these standards are one and the same. For example, it would be both an ethical violation and a crime to perform disabling surgery on a healthy person. Sometimes ethical standards and legal standards overlap or interact, and they are subject to interpretation by both legal authorities and professional oversight committees. In other cases, ethical and legal standards may conflict. For example, even though a physician has an ethical duty to maintain patient confidentiality, a court may order the release of a patient's medical records for use in a lawsuit. The American Medical Association has made a very clear statement about the relationship between ethics and law. It says, ethical values and legal principles are usually closely related, but ethical obligations typically exceed legal duties. In some cases, the law mandates unethical conduct. In general, when physicians believe a law is unjust, they should work to change the law. In exceptional circumstances of unjust laws, ethical responsibilities should supersede legal obligations. The fact that a physician charged with allegedly illegal conduct is acquitted or exonerated in civil or criminal proceedings does not necessarily mean that the physician acted ethically. The relationship between professionalism and law is a two-way street. The law sets the standards for professionalism, and standards set by a profession can provide a basis for legal responsibility. State medical practice laws are a primary source of legal standards of professionalism, but other state and federal laws also apply. Courts sometimes decide that a healthcare professional did not meet the bottom-line standard for professionalism. In other words, healthcare professionals are sometimes found legally liable for actions that are not specifically prohibited by law. A state medical practice law defines the practice of medicine and establishes a state medical board. In addition, the law specifies the method for testing medical school graduates who want to be admitted to the practice of medicine, and it sets requirements for licensing of physicians. The law also establishes procedures for enforcing professional standards, investigating complaints against physicians, and disciplining doctors where appropriate. A group called the Federation of State Medical Boards has written a model state medical practice law. However, the states are not required to follow it, so the laws governing medical practice vary from state to state. Similar laws in each state govern over healthcare professions, such as dentistry and nursing. Many states also regulate allied professions, such as physical therapy. The next two slides look at physician medical practice laws. However, it is important to remember that similar laws apply to dentists, nurses, and many other types of healthcare professionals in each state. The next two slides look at physician medical practice laws. However, it is important to remember that similar laws apply to dentists, nurses, and many other types of healthcare professionals in each state. The point is that in the culture of healthcare, the law plays a large role in the professional standards that must be met. Although legislators decide the medical practice law in each state, the state medical board is in charge of the nuts and bolts governance of the medical profession. In some states, the board is an independent entity, whereas in other states, it is part of a larger organization, such as the State Department of Health. A state medical board is usually made up of non-physician members of the community, as well as physicians. However, the Federation of State Medical Boards recommends that physicians should be the majority and should have primary responsibility for overseeing the board's licensing and education responsibilities. The typical powers and responsibilities of a state medical board include the ability to write rules and regulations based on the state medical practice law. For example, the board evaluates medical schools. It gives examinations to people who want to enter medical practice, and it investigates complaints against physicians. It is responsible for disciplining physicians it finds to be in violation of professional standards. In addition, the board deals with any individuals who are practicing medicine without a license. Other healthcare professions may also have a state board, such as a state board of nursing or a state board of pharmacy. When a state medical board receives information suggesting that a physician has violated professional standards, it initiates an investigation. If sufficient evidence is found in the investigation, the board holds a hearing or some other procedure to determine whether a violation has occurred. This process must be conducted in a way that is fair and that protects the basic rights of the physician. If a violation is found to have occurred, the board can impose a penalty. In a professional setting, a penalty is usually called a sanction. Although a sanction is a punishment in a practical sense, it is not intended to punish the individual physician. Rather, the purpose of a sanction is to protect the public from substandard medical practices. The sanction might be a monetary fine. If the physician's violation involves substandard skills, the board may order him or her to seek additional medical education. If the violation involved a medical condition, such as a drug addiction, the board might order the physician to submit to medical treatment. For serious violations, the board might also suspend or revoke the physician's medical license. Setting professional standards through medical practice laws is one example of how ethics, professionalism, and law interact. The next 2 slides discuss another way in which these concepts interact: malpractice liability. An investigation by a state medical board addresses the responsibility of the physician to the medical profession. A malpractice case is different in that it addresses the liability of a physician to an individual patient. A physician might face both a board investigation and a malpractice lawsuit for the same act or situation. There are 4 parts to proving a claim of medical malpractice. The first is that the healthcare provider had a duty to the patient who is bringing the case. This is one element where malpractice law and ethics interact. When does a specific healthcare professional have a duty to a specific patient? The second element of malpractice is that the minimum standards of care were not met in some way. Perhaps a surgeon performed an operation for which he or she was not properly trained, or a physician did not fully inform a patient about the risks of a treatment. The second element of malpractice is closely intertwined with standards of professionalism. The last 2 elements of a successful malpractice case are that the failure to meet the standard of care caused some kind of injury, and the injury resulted in damages, such as emotional distress or lost time from work. Lack of professionalism is not malpractice if it does not result in some injury, and if the injury does not result in harm to the patient. Malpractice law does not just apply to doctors. Other healthcare providers, including nurses, pharmacists, and physical therapists, can also be sued successfully if the elements of a malpractice case are met. Another way in which law, ethics, and professionalism intersect is in the self-regulation of the healthcare profession. On one hand, the healthcare profession holds itself to lofty ethical standards. On the other hand, the severity of the potential consequences can make it difficult for the profession to police itself. Most healthcare professionals behave ethically, but sometimes unethical acts or practices occur. General attributes of the culture of healthcare can make it difficult for people to report unethical behavior to their bosses or to outside authorities. Children are often told, "Do as I say, not as I do." But the lessons learned by example are very powerful. So far, this unit has outlined a strong set of ethical values that are formally taught in medical schools. However, many experts say that when it comes to prevailing ethical values, medical education contains a hidden curriculum. According to the widely discussed ideas of sociology professor Friedrich Hafferty, Medical students acquire their ethical standards in a variety of ways, some of which make up the hidden curriculum. The next slides explain how institutional policies, standards for evaluation, resource allocation decisions, and institutional language can influence what medical students learn about ethics. Students learn about values from the policies of the institution. For example, if a medical school's brochures feature statements about how much grant money its faculty members generate, this tells students that attracting money to the institution is an important internal value. How faculty are selected for promotion and what type of student is selected as chief resident also makes a statement about the values the organization embraces. The attributes and behaviors of those who are promoted may be more powerful indicators of institutional values than ethics policies or ethics classes. When students observe an institution's environment, they form ideas about what is most valued by the institution and the profession based on things like the size of faculty offices and department facilities. In addition, the language that is used day to day sends a powerful message. Professor Hafferty observed that when the language of investment professionals becomes commonly used by medical professionals, that sends a message about the relative importance of the business aspects of practicing medicine. Two other experts examined several well-known cases in which institutions refused to acknowledge ethical lapses by doctors or researchers, even after extensive investigations. The problems were exposed only when the facts of the cases were investigated by outside authorities. The conclusion from the study was that learned institutional values in medicine can create a culture in which it is difficult to report the ethical gaps of others. The study identified three general types of barriers to disclosing unethical behavior: personal motivations, institutional motivations, and shared understandings of how physicians behave. All of this leads to another area in which law, ethics, and professionalism intertwine: whistleblowing. The term whistleblower refers to someone who reports illegal or unethical behavior to his or her superiors at work or to outside authorities. A wide range of activities have been described as healthcare whistleblowing, from telling a patient about an error to disclosing violations of professional conduct that are occurring throughout an entire institution. Generally, about 6 out of 10 people who observe workplace misconduct report it to the superiors or to outside authorities. The figure may be even lower in the healthcare professions. In one study, only about 5 of 100 medical students who were in the last weeks of their training said that they would report unethical behavior. Under a federal law called the False Claims Act, citizens who have evidence of fraud against federal government contracts and programs can sue on behalf of their government in order to recover the stolen funds. In compensation for their risk and effort, the whistleblowers may be rewarded with a portion of the funds recovered, typically between 15 and 25%. In fiscal year 2011, the federal government recovered $3 billion it had paid out in false claims. Nearly all of that money, $2.8 billion, was the result of whistleblower cases. And of the $3 billion recovered, $2.4 billion was related to healthcare fraud. Prominent examples of healthcare fraud are falsified claims for Medicare and Medicaid reimbursement. About 15% of employees who report workplace misconduct faced negative consequences. According to research conducted by the Ethics Resource Center, 60% of whistleblowers who reported retaliation said they were given a cold shoulder by their coworkers. Furthermore, 62% experienced verbal abuse by a superior. In addition, 43% said that as a consequence of their whistleblowing, they did not receive promotions or raises. At the most extreme end, 4% of whistleblowers reported physical harm to themselves or their property. Many federal laws protect whistleblowers from retaliation, depending on the circumstances. For example, whistleblowers who disclose information about unsafe workplaces may be protected from job discrimination by the Federal Occupational Safety and Health Act. Unfortunately, it can be difficult to prove that a negative act, such as an employer's failure to promote a whistleblower, is really retaliation for the whistleblowing. This concludes Lecture B of Ethics and Professionalism. In summary, healthcare professionals must meet both ethical standards and legal standards. Sometimes these are the same, but not always. Ethical standards may overlap or intersect with legal standards, and the two types of standards may even conflict. Just because something is legal does not mean it is necessarily ethical. One source of legal standards for physicians is each state's medical practices law. It defines the practice of medicine within the state, establishes a state medical board, administers testing and licensing of physicians, and specifies procedures for investigation, enforcement, and discipline. The state medical board writes rules and regulations to carry out the law. A source of legal standards for all healthcare professionals is each state's malpractice laws. In order to bring a successful malpractice suit, the patient must prove that the healthcare provider had a duty to the patient, that minimum standards of care were not met, that the failure to meet the standards caused an injury, and that the injury resulted in damages. Certain values in the culture of healthcare, such as the belief in doctors' independence, make it difficult to disclose illegal or unethical behavior. The hidden curriculum in medical schools may teach students more about ethics than formal ethics training does. In 2011, a large amount of healthcare fraud was reported under the Federal False Claims Act, showing that unethical behavior is more common in the healthcare professions than people might like to think.